the census was there, they flashed this everywhere, and it was clear that they were delineating territories. And they said, well, okay, if you're in these territories that are the wrong color, maybe you're in a minority, and therefore maybe you should go somewhere else. When in fact, if you took a look at different kinds of maps in which you were showing more fine grain, you would see essentially that the map is brown, because painting something blue because of a plurality, not a majority. Remember, 3 major ethnic groups and then ethnic minorities as well. A 35%, Serbian plurality paints a territory blue, and during the war, the international community was talking about Bosnia and saying, well, division is what they really want, right? This was actually imposed by the aggressor, that division is what we should have, and there were collaborators on the Bosnian side. But the people realized that if you were in the wrong territory, you were the wrong, you were out of luck, and even if your village, for example, was a Bosniak village, and there was no Serb here, just somehow you got lumped in with this bigger town that was a few miles away, and you were in this wrong territory, and it's just the wrong conversation to have. It enables genocide itself, just to kind of paint these pictures. And then strategically became, since they're talking about these things, the Serbs said, well, okay, we're controlling some of these territories. Let's focus on turning the color of this territory. This was the ethnic cleansing policy. I don't know obviously what the conversations were, but this seems like, this was how they were thinking about things. So just you can have questions of ethnicity in a census, but then when you assign territory, pieces arbitrarily to certain colors, etc., you are really playing into that. So that's a very general statement, I guess. The first question as to whether there are mentions of what was it? The current state on the ground, the current.
No. The Serbian policy since the beginning of the war was that the intention is to create Serbian Republic. Yes. They are fighting for creation Serbian Republic.
So there was no mention. So okay, yeah. So there is no mention of the Serbian Republic as being a result of the genocide. Of course, this is what is the case. Those areas that we saw on the map, the predominantly blue areas, plus some of the green areas that were circled, those were actually conquered areas, and they were ethnically cleansed. Their term, by the way, ethnic cleansing, this is what their euphemism for genocide to make it sound less, less scary, I guess. Right, less illegal, right. And so they say this is, ethnic cleansing, and now we have cleansed it, and we have these ethnically clean territories, and they're called the Republic of the Serbs today. They still exist. And to me, this is one of the reasons why even, and this is my theory, I said I had a theory, the ICTY does not want to declare some of these areas that it doesn't have to as having gone through genocide, because the ICTY itself is something that is a mechanism for implementing the Dayton Agreement. And of course, the Dayton Agreement is the legal framework that establishes these ethnic territories within Bosnia as legal state post-genocide. And so, the ICTY calling out this would, in fact, would be the right thing to do, but it would further call into question, the very reason for the ICTY's existence, which is actually implementation of the Dayton Agreement, rather than, justice and reconciliation and these things.
My name is Gabriela Tarazona, and I am a lawyer.
And also I am a PhD, and so I teach issues related to accountability. And I just wanted to follow up to the discussion of William. Actually, one of the things that I feel that is very important is when national states internalize international treaties. You know, that's what happens with the Genocide Convention. In the way that the Genocide Convention is interpreted by the national legislation and it enters into the national arena is when you are going to have the differences in, you know, in slight interpretation. Well, let me go to the bright side. I think that accountability does exist. And one clear example is the case of Spain. I'm very, very fond of the way that Spain internalized the Genocide Convention into its national legislation. Back in the late 90s, when there was the big case of Pinochet, you know, the Augusto Pinochet that was taken in custody in London, and Spain was requesting the extradition of Pinochet into Madrid. So the Audiencia Nacional, that's the highest court in Spain, interpreted the Genocide Convention as including political crimes. So therefore, it was not just the ethnic, racial, and religious aspect of the convention itself. You know, it was also interpreted as protecting all groups. So by doing so, they were able to go after, you know, the charges. Of course, it was never extradited into Spain due to the help of the British, but it served as a watershed for the number of other issues of accountability that happened in Spain. We have Guatemalans, we have Argentinians, we have and so on. So this is perhaps the reason why we have the differences of treatment, you know, the denial of genocide.
Yeah, I think that's a great point. I think you're absolutely right. I think obviously countries have their different interpretations that we allow them to do so. And that what struck me in your discussion of the melodic version or decision in terms of that idea of significant part, right, which isn't in the definition, but is in many of the reservations that countries attached to the convention when they signed on, including the United States, that they interpreted in part to mean insignificant part. And you know, it seems to have that's kind of bled into, you know, international, or at least at the ICTY, bled into the international understanding. So that's a great point, and I'd be interested to learn maybe a little bit more about how Spain has done that, and perhaps what they base that on too.
Yes, thank you. Question?
I'd actually like to add something. I'm so glad you included this in your presentation because it was one of the numerous things that I had to exclude for time and other reasons. The Parenchek case is a very, for Armenian genocide denial, is a very important one, and it illustrates sort of the worst case scenario that was not what occurred in the two cases that I described as harmful as they may have been. Because in addition to the curious criteria that you list here, there was yet another criterion expressed in the verdict, which was that the court expressed its doubts whether an Armenian genocide ever could be proven to have occurred. So it was as if, you know, deniers had struck gold in this decision because they had this highest or very high court decision expressing its doubts on whether or not an Armenian genocide had taken place and whether such a thing could ever be proven. And I think this is exactly the type of statement that the two cases that I described in the United States were fishing for and hoping for, but didn't get. But I don't suppose it's probably the last such expedition that will take place. So thank you again for including that.
Was there, I'm sorry, follow up on that. Was there, in that decision, which does sound extraordinary, they said, was there in the proceedings a discussion of the merits of the Armenian genocide, or just how did they arrive at that?
You know, the curious thing is this, that I think as in the two American cases, it was stated more or less by definition that the case is not intended to, you know, litigate whether or not there was an Armenian genocide or not. And then it proceeded to do just that.
This factual thing of it cannot be proved was signed out only by a minority of the judges.
Oh, I thought it was a majority. I thought I thought there was a dissent. The dissenting opinion basically threw up its hands and said this is crazy. But I thought I'll have to check.
Yeah.
Okay.
Just a comment and then a sort of half question. Regarding the earlier question about whether there is any other regime than Turkey that has actually criminalized genocide recognition, per se, and we've seen that in Turkey it's kind of done through the back door, insulting Turkishness. I think the Rwandan case could be cited in that context as well, because the definition of genocide denial criminalizes this double genocide framing. And therefore, if you argue that RPF atrocities in 1994 or what happened in Congo in 1996-97 constitute genocide, that would be illegal under Rwandan law, because you would be seeking to relativize the genocide of Tutsis and so on. It has the effect, anyway, of squeezing out discussion of RPF crimes. The second point that I wanted to make, and I invite some comments from any of you about this, is should we distinguish between denying the facticity of a particular series of events and crimes on one hand versus theoretical and conceptual debates? And so what I'm thinking is, I just finished, for example, a long article on Noam Chomsky's engagement with the concept of genocide. And one of the comments he has related to the Srebrenica massacre is extremely dismissive of the idea that Srebrenica should be called genocide. He says that this is, in fact, in its way, a form of Holocaust denial or an insult to the memory of the victims of the Jewish Holocaust. Now, I don't agree with that, but I think it is a somewhat separate form to deny that Srebrenica should be called a genocide without denying that large numbers of people were murdered there. I wonder if anybody has thoughts about that.
I think that's absolutely right. I would agree with that. Absolutely. That denying that 8,000 people were killed in Srebrenica would be completely different than saying we have a debate over whether the name genocide should attach. I'm not sure if the law is really good at making those distinctions, though. And it's those issues, the idea that we constantly, with better research and everything, revise what we know about the Holocaust and other genocides, and that's great. And that's not denial, right? To change something that we thought was true, and then research says it's not denial. So then, right, Zemdel's pamphlet of, did 6 million really die? Is that really denial and minimization, or is he trying to make a argument?
I'm just asking.
Exactly. Yeah. Exactly. I will not use the word scholarly argument, but is he raising a debatable issue? So yes, personally, absolutely, they're different. Again, the law is just not really good right now at distinguishing between those two, and the more we make the law overly convoluted, the harder it is to apply it. So they leave it somewhat vague and denial. And then the court says, well, what's denial? You're saying 6 million didn't die. That's minimizing what happened. That's denial. And again, in Irving's case, where he is claiming to be more of a scholarly historian revising the record, ultimately the London court said, you're distorting the factual record. You're not revising it, you're just distorting it. And while he lost that case, it doesn't necessarily bode well for the future, I think, in terms of factually denying this never happened, and then saying, well, could this have had, right, were the RPF crimes genocidal in nature too? That definitely should be discussed, and I think that's a great point. You know, I think you're right. The dual genocide would certainly squash that in Rwanda as well.
I think that, again, this is not a legal opinion because I don't have one, but denial is rarely total, it seems to me. It certainly in the case that I know best, which is denial of the Armenian genocide, rare is the case of someone saying, in effect, it never happened. It does happen, but usually it's much more nuanced because there's a recognition that nuanced denial in certain settings is more effective than it never happened, there was no Armenian genocide. It's much more likely to shade into, well, of course, there were large numbers of Armenian deaths, but it was a time of mutual fighting, mutual killing, there was a war, there was disease, Armenians were rebelling, yada, yada, yada. And the question is whether the term genocide should be applied, not whether people suffered. You know, and this in turn leads into this focus on the word genocide is unhealthy, and we should really focus on talking about something else, which is another way of deflecting the issue.
Yeah, the word genocide does have repercussions, right? They have legal repercussions on the ground, right? So if you said that there was a massacre, and maybe there isn't even a series of massacres, and even they are ethnically, racially motivated, right? All you have to do is find, and this goes to the same point, all you have to do is find another massacre committed by the other side, and then you have made them equal, you brought them into balance. Oh, everybody did things, everybody engaged in massacres, and that is definitely a form of denial. So what we had in Bosnia was we had a side that was led by ideologues, and that was organized, and that was persistent, and that was top to bottom an organization. And so in the Srebrenica decision at the now International Court of Justice, so a separate court that it affirms that Srebrenica is a genocide perpetrated by the institutions of this entity, Republic of the Serbs, right? Which is unique. And it also says, well, the non-prevention of genocide, so Serbia as a state actor, knew about it, had the means to prevent it, and chose not to do so. So Serbia is guilty of that, and is the only state to actually be judged guilty of that. They stopped in saying that Serbia itself committed the genocide, even though they were paying the salaries of the people and arming them, and because of technicalities, because of evidence did not make it into the trial, because it was, many people know the story. But what the ICTY is doing, except in the case of Srebrenica, which is a slam dunk precisely because of the International Court of Justice decision, makes it really disputable. ICTY cannot rise and contravene that. But for every other of these towns, they purposely say, well, it is not a pattern, it is individual events, and therefore they are massacres, and they are not a genocide, and therefore we can say that everybody did some bad stuff, and therefore, we can live with the peace that we have created. This is the exact reason to say, when you say, everybody did massacres and it's not really a genocide, then it is, you can just brush it off, right? And in the Tutsi example that you had, I actually took issue with somebody saying, well, Hutus died as well. Sure they did, but putting it into a genocide context, when it was so asymmetric, is an attempt to make the sides equal, and it is an attempt to deny the genocide. At least that's how it seems.
Or to relativize it anyway.
Relativize it. Yeah.
Okay, I think we have one question back here.
Thank you. I think I want to touch a little bit what you said, Morgan or William, about the legislation or legal proceedings that go about the genocide now. And I want to ask you if you do see some positive in terms of steering some or creating a space where alternative conversations about genocide or genocidal events can take place. And again, being Armenian, the example that comes in mind was the precise the case that has been mentioned. I mean, if it was not for Amal Clooney's lead on the case, maybe that would not create as much interest or not be as much publicized. But still, I do believe that publicity creates a space where some certain ideas start to be questioned, or there is additional interest towards certain events, and it creates actually a space where we can work on combating genocide now. I just want to get your opinion on that.
It can, and it certainly, these cases that have been discussed definitely generated interest, publicity, discussion, but boy, it's a double-edged sword, because I think they've also created, or can be seen to have created a chilling effect on certain kinds of discussion as well, where, again, as I mentioned in my paper, I know of scholars, good scholars, who are afraid to write that scholar X is engaging in genocide denial in work Y because of the fear of being sued. And that's, I think, a much desired byproduct of these cases, in fact, and one of the reasons why they were developed in the first case, to sort of cast a pall over the entire topic, and again, to render it inherently controversial. Well, of course there's a controversy about whether there was an Armenian genocide. There were lawsuits, right? It's sort of, again, it's circular reasoning. There wouldn't be lawsuits if it weren't controversial. So, I don't know.
And lawsuit, and you know, legally speaking, court decisions are always a toss-up, whether that's a good idea to pursue that or not, because you could end up with this, right, in Parenchek's situation, or you could end up with the Irving situation, which more or less confirmed everything we knew about the Holocaust, right? And it's a toss-up, because you're setting yourself up to potentially fail and get a decision that says, oh, well, yeah, Armenia is debatable. It's open to debate, and the Turkish side should be heard fairly and equally. But the Turkish side isn't coming at it fair and equally. Right? They're not coming at it from the same side, and which is why I think the cases you mentioned were great, because the decisions really were more about the fact that this is an educational decision. This is not an opinion. This is about educating students. And at least in this country, education you get a little more leeway from from court intervention, right? But in other situations, right? Again, in this one, you set yourself up thinking, oh, we'll get a decision that says Armenia is not debatable, and we get the opposite. And now, right, Turkish officials can say, as you mentioned, throw their hands up, yay, it's debatable. We're not denying it. The court told us.
That's right.
Great. I know there are a few more questions, but we are out of time. So this is a great conversation, and I hope that we can continue it and you guys will be available. I think that a few of the really interesting things that popped up, particularly are like the trickiness of language, and if we leave room to interpret the law, then we leave spaces for denial. And also the importance of teaching and pedagogy, and how critical literacy, but also, where do you get your facts, and how do we know that these are facts, and that history and the law are always interpretations of those things, and that's what we need to teach our students. So I have got a ton of notes. I'm very excited that you are all here, so thank you very much. And I will remind you, we do have a 15-minute break for coffee and snacks, and the toilets are just down the hallway on the right. And then the panel 4 in the next session has been canceled. Our panelists couldn't be here for that one. So you'll have 2 to choose from as well. So have a great break, and feel free to ask a few more questions and keep the dialogue going. Thank you.